and this day being January 28th, which is the Data Protection Day. For those who are joining, just a little about the day. It's an international day where we observe the dedicated. We dedicate this day to observe the raising awareness about the importance of privacy and responsible data handling and protection of personal information in our increasingly digital world. So this year, the Data Protection Day emphasizes not just compliance with legal frameworks, but the broader responsibility of building trust, accountability, and ethical governance in digital ecosystems. So as we gather for this webinar, we do so in the spirit of that observance and to reflect whether East Africa's data protection laws are keeping pace with the rapid technological changes that are happening across our board. And we are also today exploring how legal practitioners, regulators, and institutions are strengthening data protection laws across board. And I feel this is a very timely conversation to help us navigate and explore the challenges in the region. And to take us through that session this afternoon is a lady whom just a few days ago I had a very interesting conversation with. And we decided to put this up. And ladies and gentlemen, that is none other than Miss Wendy Kuyo, a very eminent data protection lawyer in East Africa. And I'm quite honored that she sits on our data protection committee and that she's guiding this presentation. So Wendy, our dream has come alive, and now it's time for us to take this conversation forward. Over to you, Wendy.
Thank you very much, Gabriel, and such a timely conversation. Thank you for organizing this as well, and good afternoon, members and guests. Once again, I would take the chance to say Happy Data Protection Day and introduce today's theme, as well as that we'll look into whether the current East Africa regimes are fit for the digital economy we have, and that how the legal frameworks currently in place in each the countries evolve to rebuild trust, strengthen compliance as well, and safeguard rights in an increasingly data-driven world. So this, of course, as anticipated by Gabriel, is quite a timely and high-level session that we look into, have gathered quite a few experts from different countries. And I emphasize trust because this has also been the theme this week at the annual Kenyan Data Protection Conference that has been ongoing for the past 2 days and sadly concludes today, but with great insights from different stakeholders. So just to emphasize, and also as mentioned by Gabriel, the significance of this day, why have we come together on the 28th of January and not any other day? Back in 2006, this date marks the anniversary of the opening of a signature of a convention that would ideally raise awareness on the need to respect and protect individuals' privacy. So for the last 45 years, this Convention 108 has contributed to the development of privacy and data protection, not only within the European data protection space, but also far beyond, and now we can see it closer to home within the East African region. So today with us, we have a few speakers, and I will introduce them as they go along, but I would like to first introduce a good friend, Mr. Alfred Nyaga, who is also a Commonwealth scholar and the founder of Digital Ethics Hub. His focus areas today would revolve around ethical governance of data in this age of artificial intelligence. Very important that we mention this also, as we mentioned, data protection and privacy. He will also highlight issues to do with privacy by design, balance innovation, surveillance, etc. So I would like to take the chance to kindly welcome Alfred to share your valuable insights. Thank you very much.
Thank you so much, Wendy. I hope I'm audible.
Yes, we can hear you. Thank you.
Okay. Allow me to share my slide with everyone. Please confirm that you can see the slides. Oh, nice. So thank you so much, Wendy, for that kind introduction. So I'll be taking you through a topic, trust, technology, and the new privacy frontier. And this is how the presentation is going to flow. So allow me if... Wendy, can you see the slides?
We can see the slides, only I think it's on freeze and there was quite a bit of static. Can you try again?
Okay.
Are you speaking, Alfred?
What about, can you see the slides now?
Yes, we can see the slides. Are they moving? Are you trying to move the cursor?
No, they are now on the
Yes, we can
presentation
see.
overview. Oh, nice. If you are not able to see,
Okay,
please
please.
just alert me. So basically, this is the presentation overview. We're going to start with the ethical governance of data in the age of AI and biometrics. We'll move to embedding privacy by design and default in data governance. Then we'll move to balancing innovation, surveillance, and individual rights. Then lastly, we'll look at rethinking privacy in the digital age. So the first topic, ethical governance of AI in the age of AI and biometrics. So basically, first of all, I forgot to say Happy International Privacy Day, Data Privacy Day. And as we commemorate this important day, it's important to note that in the age of AI, privacy isn't just a compliance feature, but it's actually a foundation of digital trust and a fundamental design or architecture, or what is normally called artificial intelligence has evolved. These AI systems do not just store data, they make inferences about people. That is, they make predictions about people, and they also automate decisions which have real consequences. For instance, AI systems can be used to automate decisions such as decisions on whether you as a data subject you qualify for a loan, or actually decisions with regards to recruitment, whether you fit in a certain role. And these particular automated decisions actually have very severe consequences, especially in terms of privacy, bias, discrimination, and all that. Then AI and biometric identification systems, which we'll talk about later on in this presentation, have amplified risks on data privacy. And some of high-risk biometric use cases in East Africa include what we now have in some of our East African countries, known as the national digital IDs. In Kenya, it's referred to as Maisha number. I believe in Tanzania, it's Jamii number. Then we also have the use of biometric identifications in border controls. These are things to do with facial recognition technologies, which are able to identify maybe suspects at the borders or something of that sort. Then we also have the use of these biometrics or artificial AI-powered surveillance in law enforcement. And we've seen recently the use of these technologies in things to do with tracking of people, police using these technologies to track down people and suspects. But now the main question is, what are the measures taken by these authorities before deployment of such AI-powered technologies? We'll have brainstorming session with you later on this presentation, where we reflect on such issues. Then actually require transparency and accountability so that you can privacy and data protection. On the fourth slide, then we'll talk on the rise of AI and data-driven economies in East Africa. So basically, as I've said, AI has rapidly evolved, and these artificial intelligence models or systems rely on massive data sets for their training, development, upgrade, and decision making. So if you look at what has been trending recently in terms of this space, you'll note a lot of scholars, data protection authorities have noted that AI is what we call data hungry. And this means that AI is relying a lot on personal data. And this personal data is usually, most of the time, collected through what we call web scraping. And this scraping is usually collecting of personal data or personal information, which is freely available online. For instance, I know all of us have a digital footprint that we have either a social media account, or we post something online that is in terms of content. So some of these AI tools have been scraping a lot of that personal information, our images and all that. For instance, if you can remember, there is a case of Clearview AI, which was scraping a lot of personal images for facial recognition purposes. And that Clearview company, which is, I believe, a US-based company, was actually heavily sanctioned in the EU. So we move on to the next slide. That's slide 5. I hope you can still see the slides. Wendy, please confirm.
Confirm.
Nice. So slide 5, that is privacy risks in the age of AI. Now that we've said that AI has evolved to be widely used in various aspects of our life, and actually AI has been integrated into very many aspects of our life. But now the main question is, what are the privacy risks that these artificial intelligence tools or systems or models pose to privacy, data privacy? Number one is unauthorized access, collection, and retention of data. And this is in terms of, as I've said, these AI tools process large amounts of personal data for their training, development, upgrade, decision-making, etc. So this data, most of the time, is scraped online. And again, there's been another new thing of how these AI models actually get personal data. That is development of synthetic data. It's actually a new thing, which is currently evolving, where now the AI model is able to basically come up with synthetic data, which is based on personal data, but now it's more of AI developed so that they can be able to be trained. Then we have collection, which is like how they process this data, and issues of retention. Because if you look at how AI is trained, that data is embedded into what we call deep neural networks within the AI systems. And removing this personal data in AI systems, most of the scholars actually say it's like trying to remove ingredients of a baked cake. That is, if you bake a cake and you use flour, you use eggs, margarine, and all that, removing personal data is like trying to remove those ingredients of a baked cake. So basically what I mean is it's very difficult to remove personal data, which was used in training of AI from those deep neural networks. Then we have issues of data breaches. Again, because AI is processing a lot of personal data, that data is actually like there's high chances of cyber attacks. And if that happens, then a lot of personal data is actually obtained through those cyber attacks, and that leads to data breaches. Then we have what we call algorithmic bias and discrimination. And this means that AI tools are able to make predictions or have outcomes which are actually biased and discriminatory. That is, these outcomes are actually unfair and they can have discriminatory aspects. And this discrimination can be in terms of whether it's gender, racial, and all those other forms of discrimination. Then we have intrusive surveillance or mass surveillance. This is surveillance where basically there's a lot of monitoring of people and their private life, and this actually breaches people's privacy. Then we have what you call AI black box. Some people call it opacity. So this means that the operations of artificial intelligence are actually not clearly known by its users. Like, you cannot be able to tell how your personal data is, number one, processed by AI, and you can't even tell how that personal data was in the first place obtained or collected to train those AI algorithms. So it becomes like the operations of AI are in a black box, and they are not, it's not easily to basically know how the AI is operating. And that brings us to the last point of lack of transparency and accountability, where we say that the operations of AI are not transparent and accountable, and that makes basically like data subjects are not aware of how, when, and where their personal data was used in training of AI models. And in the end, we have issues of violations of privacy and data protection. On the 6th slide, so I would like us to reflect on something before we proceed on this presentation. So the reflection is, are the existing data protection laws in East Africa truly tailored for AI complexities, that is in terms of large-scale data processing, black box, consent fallacies, and all that? So basically, we are asking ourselves, are these the existing data privacy laws we have in Kenya, Tanzania, Rwanda, and the other South African countries, are they truly really applicable in this AI era, or is the technology more advanced than the law itself? Because if you look at the website, like, AI is processing a lot of personal data, where the data protection, the traditional data protection laws really did they foresee these kind of issues in terms of data being processed in large amounts, issues of black box? Then we also have issues of consent. It's a fallacy in this AI era because it's not easy for AI deployers to ask for consent from every other data subjects before they train AI using that personal data. So really the existing data protection laws really adjustable to these AI technologies? Then we move on to slide 7. So basically, as we proceed, just keep on asking yourself this particular question, and I hope we'll have the answer by the end of this presentation. So slide 7, we look at issues of privacy by design and issues of privacy by default in data governance. So basically, privacy by design and privacy by default should not be basically an afterthought when deploying AI systems. They should actually be embedded in those AI systems, and this can be through firstly conducting of data impact assessments. This can be data protection impact assessments, algorithmic impact assessments, and fundamental rights impact assessments. This is to assess the risks the AI systems have on privacy and data protection. Then adherence to, Wendy, please confirm that my audio and video are okay. I can see a comment that they are not okay.
So you had quite a bit of static, but I think we were able to follow along. And I think for now, for most part of it, a bit clearer than before. So if the issue persists, I would propose that you switch off your camera. that would work.
Okay. Okay. I'm actually using a webcam. I don't know why it's okay. Let's see. If there are further issues, just let me know so that I switch my network and also I switch off my camera.
Okay.
So I was talking about adherence to the rights of data subjects. These are rights such as rights to be forgotten, that is right of erasure in terms of data which was used, deletion of personal data which was used in training or AI models, rights of information, that is to know how the personal data is used in terms of training AI systems. Then adherence to the principles of data protection, that is in terms of principles such as data minimization, that is the use of the necessary data, storage limitation, that is the data should have a limitation as to when it can be used in AI training and things to do with purpose limitation. Then we have transparency and accountability. So basically, transparency and accountability should be embedded in this when deploying AI systems, such that we don't have issues of opacity, black box, etc. Then if you look at most of these, let me say, websites and all that, other platforms, you'll note that most of the time we don't have the opt-in, let me say a button or something. Most of the time you are actually supposed to opt out. So that's why we say in this privacy by design that it should actually be opt-in, not opt-out. Then issues of there should be no dark pattern. Dark patterns actually means that these manipulative interfaces that basically manipulate the users, and this manipulation can be maybe to make a purchase or something of that sort, and these dark patterns could actually have hidden costs tied to it. Move on to slide 8. The growth of surveillance technologies in East Africa. So basically, if you look at the recent things which have been happening, these governments in East Africa have been increasingly adopting surveillance, digital surveillance technologies for national security and public safety. And most of the time, this actually in terms of tracking of people, or sometimes in terms of facial recognition technology. Then remember that when it comes to facial recognition technologies, the data which is being processed is biometric data. And biometric data is part of sensitive personal data, or what people call special category of data, and attracts more strict requirements. Then in terms of private sector, there's been a lot of adoption of access controls and marketing. Access controls could either be those fingerprints before you access a building, or basically CCTVs and all that. Slide 9. We look at ethical and legal and ethical issues of surveillance. So basically, if you look at it, you have these issues of your face belongs to us, or the big brother is watching and all that. So this means that there's a lot of surveillance, that is in terms of digital surveillance, AI-powered surveillance, which is actually going on. And we all know that this actually, this kind of surveillance has a chilling effect on fundamental rights, including the right to privacy and other rights such as freedom of expression and all that. Then this mass surveillance violates this right to privacy, because first of all, there is no transparency on how the data which is collected from on the kind of data which is collected through such kind of digital surveillance. Then most of the time there is no consent, especially when it comes to digital surveillance, biometric identification, facial recognition technologies, and all that. Then one of the issues we've been having in East Africa is this kind of technologies being used for political dissent. I mean, if you are not, you are against maybe the government, or you have some ideologies which are against the government. Then there's issues of tracking, so that the silencing of dissent and political control. Then there are no safeguards and oversight mechanisms. And at the end of the day, these issues, actually, there's a lot of, if you look at it, there's a lot of privacy and data protection violations. We'll move to slide 10, surveillance and data privacy concerns. So I believe most of these we've actually covered, but in terms of sensitivity of biometric data, as I've mentioned, this kind of data is considered sensitive personal data, and actually attracts more stringent requirements, unlike the normal or the general personal data. Then in terms of digital surveillance, there could actually be issues of misidentification. This means that a wrong person can be identified. Let's say it's issues of border controls, and these kind of technologies have been deployed to actually, let's say, be able to identify suspects. There could be issues of false positives and misidentification in regards to wrong people being identified by these kind of technologies. And there is usually no consent and transparency in the way these surveillance technologies are actually deployed. And these technologies are actually used in terms of cross-platform data sharing. And what I mean is, for example, if you look at facial recognition technologies, there are two platforms involved. There's the cameras, which are now used to scan the facial features and all that. That is the first platform. Then that data is transferred to another platform, which is used to match the faces which have been scanned to already existing faces in their database. So that means that there's a lot of cross-platform data sharing, which raises a lot of concerns. Then issues of bias and discrimination in regards to unfair and discriminatory outcomes from these digital surveillance technologies. We'll move on to slide 11. So the main question then becomes, how do we balance surveillance, digital surveillance, with privacy? So first of all, the state also has interest in terms of national security, and the citizens also have rights to privacy, among other fundamental rights. So there is a need to balance these two competing interests, the issue of national security and the issue of citizen rights to privacy. So there is an issue of balancing these two competing interests. Then this digital surveillance should be proportionate and necessary. So there's, in terms of that, surveillance should actually be necessary and proportionate. Then the surveillance, I mean, a lot of courts, especially here in Kenya, have had the view that the surveillance should be objective and not subjective. Then last slide. So as we've said, AI is reshaping the way East Africa. So we believe that it is time to reshape the future privacy law and align it with AI advancements in East Africa. Back to you, Wendy.
Thank you very much, Alfred. Despite the small issues, I think you are very clear, and thank you very much for already bringing out this aspect of embedding ethics in the use of AI. And thank you also for highlighting these issues that may come along in fundamental processes. You've mentioned recruitment during HR practices. You've mentioned even surveillance in law enforcement. And with this, I make reference to a documentary and now recently published book by Dr. Joy Bolawini, who is a lecturer at Stanford, who explored these whole issues of AI bias, the ethical implications of facial recognition. And at the time, what stood out for me was that at the time, she was a student at Massachusetts at the time, and during her research, she realized that AI systems were trained with non-diverse data sets. And therefore, only when she could wear a white mask, the system could detect her. So there was issues of bias, etc. And just as Alfred has mentioned, we are officially living in your face belongs to the system era. And no, we didn't all sign up that consent form. And as Alfred has stated again, consent is a fallacy in this era. So, and just as highlighted as well, mass surveillance doesn't just collect data, it tests the limit of fundamental rights. And when you talk about fundamental rights, we don't just talk about the right to privacy, we have also the right to dignity as well. So in conclusions, AI decisions should not feel like magic or worse, fate. And with this, I would like also to kindly ask Mr. David, who is an associate at Trust Law Chambers. Mr. David is a skilled legal professional with extensive experience in intellectual property law, compliance, and technology law. So David is going to highlight this theme of what compliance looks like and what trust in practice looks like, and highlighting some practical challenges. And just to assure the members and guests as well that we will have a Q&A session, keep brainstorming. You can write as well the questions on the chat if you don't want them to get off your mind already, but we will have a Q&A session where the panelists will be able to answer these questions. Over to you, David.
Thank you very much, Wendy. And thank you very much, Alfred. Your presentation was quite insightful, especially regarding artificial intelligence. I know we cannot talk about any topic today without mentioning the words artificial intelligence. So in as much as you've handled it quite in depth in my presentation as well, don't be shocked if you see artificial intelligence. In fact, I will attempt to answer the question that you raised, whether the data protection laws are capable of applying to artificial intelligence in the state that they are in right now. I think that's one of the most interesting questions, especially since we don't have any particular artificial intelligence law. Yes, there is there's the European Union law, the AI law, but we know that we haven't yet adapted that, like how we adapted the GDPR, and that time is coming. I'm sure a number of countries are going to be forced to adopt it simply because they must obtain funds from different international bodies. We're yet to see that, but that hasn't yet happened. So we don't have any artificial intelligence law, and I think the question is, what do we do? So Wendy also mentioned earlier on regarding the theme for the International Data Protection Day, which is trust, and I think you can see that from the title of my presentation, Operationalizing Trust in 2026, from compliance checkboxes to organizational culture. I think one of the most popular messages that I'm hearing from the different webinars today regarding data protection is that it's not enough to simply have a certificate. It's not enough to simply check the box that, oh, we have a data protection policy, or we have a retention policy. It's also important that we go into our organizations and create this culture of compliance when it comes to data protection. It starts with the data protection officer, who needs to train the rest of the organization into understanding what are our data protection handling processes. How do we ensure that while we are handling personal data, we, for instance, respect privacy by design, as explained by Alfred, and things like that. I think that's what it would that's what it would mean to have an organizational culture that is data compliant. So for particularly in Rwanda, I think you understand that the honeymoon is over. I say the honeymoon is over because there was a particular grace period that they gave that they gave companies, especially those who are already processing personal data, since the law came while they had already started these processes. They were given 2 years within which to figure it out and apply and register. Those 2 years have since passed. I don't know what it is for the other countries like Uganda and Kenya, and whether a grace period was even given. However, since I am conversant with certain enforcement measures that have been taken in, for instance, Kenya. I am aware that strict enforcement has started in those countries, and I think it's yet to translate here in Rwanda. But I believe that the honeymoon is over. It's not a situation whereby the National Cybersecurity Authority is holding people's hands anymore. Now it's about comply, comply, comply. And if you don't comply, here is the implication. Here are the consequences. It could lead to imprisonment. Data breaches could lead to hefty fines that could cause your company to stifle. Now, I don't know how it is for many of you practitioners, but I think for me, these three types of companies are the main types of companies that I've had to deal with in data protection. One, there are those companies that heard about the law. They decided to create a data protection policy, put it on the shelf and say that, you know what, we're compliant, we got this. There's that type of company. There's type B, the operationalizer. I call that the shelf warmer. Now there's the operationalizer, the one who realizes that compliance is not a certificate, but it's a daily operational habit. And they are constantly integrating compliance within their data processing, within their handling processes. Then finally, there is a type C, the avoider, especially startups and innovators. Every time I meet an innovator or a startup or a founder, they say, no, yes, you say that compliance with data protection is going to be my main compliance risk, but I have just started. I'm not really dealing with that much data. I'm not really dealing with that many data subjects. I don't really need a data protection officer. In other words, I don't really need a data protection certificate at the start. Well, I think I beg to disagree with them a lot, but it's very difficult to convince them of the purpose at the start. The only thing that we have to use, I think, to not even to inspire them, but to scare them, is the different fines in the law. And I think it's important that we find ways of incentivizing registration for startups. And I think we'll see later on that the thresholds for mandatory registration in different countries differ from region to region. So we'll as well look at that. But for now, these are the main three companies. Yes, someone will come and say that there is a fourth type of company, the one that says that, hey, you know what, I don't know about data protection. I didn't even know I was handling personal data. Well, that was the purpose of the main title here, saying the honeymoon is over. Since that grace period has since elapsed, currently, now, ignorance is no defense to the law. So you can't say you didn't know, and that doesn't count anymore. So even while we're trying to come up with solutions and ways for lawyers to come up with creative methods of ensuring that the companies they represent are compliant, I think these are the three main companies that we'll be looking at. What they all have in common is the fact that compliance is burdensome. And from many, and I'm sure many of you know this. They say compliance is burdensome in many ways, by the way. And I think one of the most common ones is consent, because in all the laws, whether it is Kenya, whether it is Uganda, whether it is Rwanda, we understand that the main ground that gives you basis for collecting personal data is consent. But do you know how difficult it is for a company to figure out a way to collect consent in the different data handling processes that they have? I think currently that's the struggle that we have, even as lawyers, because someone will come and tell you that, you know what, we deal with clients. Sometimes they come, we deal with guests, for instance. A guest comes, asks what we do, and never comes back, surely. Do I need to collect their consent as well? This is a one-time one-off. Well, the law doesn't specify. The law requires that consent must be collected. For instance, if you have a CCTV camera that's recording your guests, you are technically collecting their personal data. They must know that those cameras exist. They must know the reason why those cameras were put in place. And it is up to you as the company, of course, in discussion maybe with your lawyers and maybe your data protection officer, to figure out how do we collect that informed consent from such a a data subject. I think these are the main problems that we are suffering. And someone might think that all this has to do mainly with the digital, but if you look at many of the softwares that people are using today, they're sort of outdated. They're outdated, but companies don't exactly have the money to modernize their softwares, to build other softwares. So one of the biggest problems that a company will come up and tell you, yes, Alfred, I've heard you talking about privacy by design, and I should build from the ground up thinking about privacy within my app. But I already have the app. I've already spent money on it, and now I'm just dealing with costs of maintenance. How then does privacy by design come in? If you look at the example here that is on your screen, it's intentionally showing a very old system. This is supposed to represent a bank system whereby someone comes in and tells the bank teller that, you know what, I want to open my bank account, but I don't want my data to be used, for instance, for data scoring, for automated data scoring, or I want to create a bank account, but I don't want insurers to get my third-party info. I mean, to get my information. And then the bank teller will probably try to do that, but the system won't allow them because they'll find a mandatory. There's normally now a mandatory indicator showing you that this field must be completed. In other words, if you don't want your data to be shared with those third parties, we can't offer you our service. You can't have an account unless you accept us to use your data for these other things. It's sort of a very difficult thing to see the rights of a data subject in practice, being enforced in practice. And I think, again, these are the creative things that we need to come up with. So I don't think that the problem is the law. I think that the law demands 21st century rights, but the banking systems, for instance, which are probably a decade old, cannot even accept these new rights, such as to withdraw consent. That, oh no, I had accepted to open my bank account, but I don't want you to use my information for credit scoring. Is that a possibility? I highly doubt. Will you have a bank account without that option? Maybe that's a product that banks are yet to create because of the data protection laws. I think we are yet to see. Another thing that I wanted to discuss for my part is to just talk about some of the hurdles that I've seen, or the should I call them the trends that I'm seeing in the way the regulations are in the different countries. If you look at the slide there, it says the myth of harmonization, the East African standoff. So while we speak of regional integration, distinct regulatory personalities have emerged. The fintechs and e-commerce platforms must understand these regulatory personalities. For instance, if we talk about Kenya under Article 18 of their data protection law, specifically subsection 2, allows the data commissioner to establish thresholds based on, for instance, the nature of the industry, the volumes of the data processed, and whether sensitive personal data is being processed. So you might find that there is certain companies that do not meet the threshold for mandatory registration. And this is why I say that there is a sandbox. The sandbox, in other words, it sort of supports innovation. There's certain companies that if they've just started, why are we forcing them to register? Because the compliance is sort of also difficult. As far as cost is concerned, you must hire a data protection officer. You must carry out a data protection impact assessment. So many companies do not have the capacity, the human resource capacity to do this. And it requires money to hire someone. It requires money to hire lawyers to help you apply for registration. And if we don't create thresholds such as that, it means that in every other country, it means that then no matter who you are, whether you just started or not, you must register as a data controller or a data processor. So I think the method in Kenya is a bit better because it creates or provides for the creation of these thresholds. It's definitely different in Rwanda and Uganda. For instance, in Rwanda, Article 29 is strict. It says as long as you are a data controller or a data processor, you must register. So, and I think that's the same situation for Uganda. So if you think about it, the impact, a two-person e-commerce startup in Kigali has the same registration burden as a telecom giant. This is a unique challenge for the digital ecosystem. Compliance costs hit SMEs harder than these other big companies, and this is the situation especially for Rwanda. So I believe that the idea of creating thresholds for mandatory registration is also very, very, very important. An SME, a fintech, or an e-commerce platform that is trying to register and start business in East Africa might have to make these considerations in determining whether they want to be registered in Kenya, whether they want to be registered in Tanzania, or in Uganda, or in Rwanda. Now, I think the second comparison is when it comes to data localization. So data localization simply means countries requiring you to store personal data within the borders of the country. If you look at Rwanda, the situation, let me just finish the slide. Let me just move on to the next slide. Data localization philosophies. If you look at Rwanda, there's a store here by default, which is the sovereignty approach. So Article 50 of the law that governs protection of personal data in Rwanda states that the data controller or the data processor must store personal data in Rwanda. However, the storage of personal data outside Rwanda is only permitted if the data controller or the data processor holds a valid registration certificate authorizing him or her to store personal data outside Rwanda. And this is issued by the National Cybersecurity Authority. That article is different in the Kenyan law. Sections 48 to 50 of the Kenyan law provide for transfer of personal data outside of Kenya. Specifically, Section 50 states that the Cabinet Secretary may prescribe, based on grounds of strategic interests of the state or protection of revenue, certain nature of processing that shall only be effected through a server or a data center located in Kenya. So it's sort of saying that in general, the idea is that you can store outside, and in certain scenarios, which scenarios will be provided for by the Cabinet Secretary, which scenarios will be of a strategic nature based on strategic grounds, will you be forced to store your data only in Kenya. When you come to Uganda, Uganda is an interesting one because all it requires is adequacy of safety measures. If you look at Section 19 of the Data Protection Act 2019 of Uganda, it simply says where a data processor wants to store their data outside, they must ensure that the country in which the data is processed or stored has adequate measures in place for the protection of personal data, at least equivalent to the protection provided for by this Act. What they require is that where you're storing the personal data, they at least have measures, safeguards that have been put in place to protect that personal data, similar to the ones that are being provided for in the Act. If you look at those three scenarios, you realize that they are very much different. So you may think that that maybe the situation in Rwanda is a bad one. As much as that friction is intentional, it forces the creation of a local data center economy. So they're looking towards the future and trying to promote the idea of having an economy that supports data centers, having us build data centers here and having our data having our data stored in Rwanda, locally in Rwanda. But then the big problem that comes with that is that it creates another layer of compliance. And if you see the image there, there's 4 documents. I'm sort of implying that in Rwanda, you may be required to look for 4 different certificates. If you're a data controller, you need a data controller certificate. If you're a processor, you need a processing certificate on top of that. If you're a data controller or data processor who intends to transfer personal data outside of Rwanda, you need another certificate for authorization to transfer data outside of Rwanda. If you also want to store personal data, maybe because you don't have the capacity here in Rwanda, or you don't have the servers, or maybe your headquarters are stationed somewhere else and that is where the servers are, you find yourself having to apply for another authorization, which is authorization to store personal data outside of Rwanda. So yeah, I understand, and you can tell that you understand the need for this protection because also the need of promoting data center economies, but you can also see how difficult it can be, for instance, for a startup or an innovator trying to be compliant at the start. And maybe we can also discuss what you think about these differences in localization and whether they actually affect businesses, or if you feel that these are just theoretical things that do not really disturb a business. In my opinion, I believe they do so much, especially for lawyers who are working cross-border and are advising different companies, that multinational companies. You realize that the trends in data protection in Rwanda somehow are very different in nuances, especially the requirements and other. I'm just picking out the general ones that I believe should be discussed. Now, let me quickly move on to artificial intelligence. This was handled quite in depth by Alfred, so I won't delve too much into it. But we all know that data is the raw material of artificial intelligence, and we keep on saying this. We even say artificial intelligence should be raised like a child, and a child is raised by a village. But even the child in the village, really, we expose them to knowledge and knowledge from the different people in the village. So I believe that's where they get their information while they grow. And still, this has to do with data. So the idea is that if we can control the data, we sort of have some sort of first line defense when it comes to the breaches of data that may be caused by artificial intelligence. Many of which that have been mentioned by Alfred. You think about them in algorithmic bias. If you think about algorithmic bias, you know that the data protection law provides for a right not to be discriminated against by your personal data. That's there. It's there, but how do we implement it? How do we enforce it in situations of AI bias? I think that's what we need to think about. The other 2 main points that I think are important when it comes to using the data protection law as our first line of defense in relation to artificial intelligence related data breaches is the point of informed consent. So Alfred also mentioned the idea that there's a lot of companies that are scraping personal data from different company profiles, from your social media profiles, and they're using your personal data to train these models. But you know that the law requires informed consent. And there's a problem when we try to describe what do we mean by informed consent. Is consent described the same way in Kenya as it is in Uganda? I think those are questions that require more time, but specifically if you think about it, informed consent means that if I consent to you using my personal data to deliver a package to my home, I am not consenting to you using that same personal data to train an AI-powered delivery drone, if you get what I mean. The company that is using that information to train the AI drone must specifically request for consent separate from the one that they asked for when they were just delivering the package. Why? Because, again, the data protection law provides for rights that the data subject is entitled to, and this includes the right to be informed that your data is being collected, the right to be informed that your data is being collected for this and this purpose, so that when that purpose is complete, there is no need to have your data anymore. That is the right to be forgotten. It also has to do with purpose limitation, limiting use of personal data to the purpose it has been collected for. The other point when it comes to algorithms, again, is that there is specific provisions within all the East African laws, and I think I can confirm that because I checked specifically Kenya, Uganda, and Rwanda. So for Rwanda, we use Article 22, sorry, of the Data Protection Law, which mandates that if you are going to use someone's personal data for automated decision making, you must seek their consent. This is separate from the general informed consent we've been talking about here. It is a separate provision that is making it important to inform people that, hey, I am using your data for automated AI credit scoring. That, hey, you're applying for this job. We want you to know that we're going to use your personal data in an AI-powered automated HR selection tool. These are things that companies must know so that they remain compliant with the law. But again, to remind you, in answer to Alfred's question, the data protection law may not be robust enough to handle the complexities that Alfred has outlined. That's true. However, we can use the data protection law as a first line of defense, specifically these articles, to say that the data subject has the right to say no, the data subject has the right to be informed. So what do we mean exactly for the theme in this International Data Protection Day when we say trust? Trust. I think what we mean is that data subjects, your partners, your clients, your customers will trust you more, will trust your reputation more if you're compliant with data protection laws. If you are a data controller, you must have a data protection certificate. If you want to deal with, for instance, European gateways, they'll demand that you have a data protection policy. This must already be in place. If you want to deal with companies that have multinational contracts, they might demand to see your standard contractual clauses. What are your standard contractual clauses when it comes to transfer of personal data for these multinational contracts and companies? So don't look at the certificate. If you see there down, don't look at the certificate as a receipt. It's a passport to global markets. It's your way to dealing on the global scene with a reputation that's well respected and that with a brand that's well trusted and services that are well trusted, and people are not going to fear to deal with you because they've heard that, oh, no, there's a lot of scam artists now. Are you really clicking agree? Don't just click on accept if you don't think this company is reputable. Have you really checked their website? So there are so many companies that will outrightly come out on their websites and let you know that, hey, we are compliant with data protection. Here is our data protection policy. Here is where you need to report in case there is a data breach. This is our data protection officer. This is their number. This is their email. Reach out in case there is a complaint, a breach. You need to provide those platforms so that you create this sort of trust when it comes to personal data. So finally, trust is the product. Of course, the companies that are struggling will definitely view compliance as a tax on their business. But if you want to be, if you want to lead this field, if you want to be ahead of compliance and ensure compliance is always there, then you look at it as a badge of quality. Compliance is a badge of quality. You're letting people know that our services, our products are quality because we ensure that your personal data is protected. So in a digital economy, customers do not buy products they fear. Compliance inspires trust when people engage with your services, and that's the main point. Yeah, I think for reasons of time, please allow me to stop here, but I had really reached the end. Compliance is hard, it is messy, it involves 20-page forms like the data protection impact assessments, but it is the price of admission to the future. Thank you very much.
Thank you very much, David. Quite insightful thoughts. Certainly, the honeymoon is over. And we can see this in here in Kenya as well. There has been, from a report that has been recently combined by the Data Protection Governance Society of Kenya. Last year alone, the Office of the Data Protection Commissioner issued over 90 determinations. And this is nearly double of the determinations that were issued in 2024. And of course, triple in or more, even more in the previous years. Also from Uganda, I read a while ago that the Personal Data Protection Office secured its first criminal conviction under the Data Protection and Privacy Act of 2019. And just as David has mentioned, there comes along with several obligations with these pieces of legislation, and this conviction also, one of the counts related to failure of the company to register as a data controller and processor. Interestingly, you also mentioned a consent and pointed out that it is not the only legal basis. And ideally, when companies or rather businesses translate the companies and businesses translate a positive return of investment where there is trust between the businesses and their consumers. So even if there are other legal bases that are relied on, for instance, a contract, then it is important to certainly to provide a transparent information notice, of course, depending on the audience, whether it's a child and how is this notice written? Can the child understand? Is it persons with a disability or rather persons who are differently able? How can this be understood? A good example is that if you believe you will incentivize me as a consumer, as a shopper, to keep buying your goods, and that I can have some discount coupons each time I shop, will you be transparent enough about the fact that you will probably use this data that you are putting in this so-called discount or rather points card for further analytics and to check the trends of the shoppers and ultimately know what you will sell to me in the future if probably I do not appear in your shop the next day. You also kindly highlighted about the use of this training of the AI system for the AI-powered drone, if perhaps contractually the consumer and the business have agreed that they will receive a package under the contractual and necessity basis. Ultimately, trust is the product. Moving on, I see from the chat that one participant asked for insight from Tanzania, and here we are. I would like to kindly invite Ms. Dorothy Andate, who is a quite highly qualified legal professional with over 10 years of experience in telecommunications, media and technology law, employment law, and just to mention but a few. So she is going to highlight the role of these supervisory authorities and specifically data protection authorities in the different countries, the investigations, the audits, the fines, and the enforcement discretion, and just to mention a few. You're very welcome, Ms. Dorothy, to share your valuable insights. Thank you very much in advance.
Thank you, Wendy. Good afternoon, distinguished colleagues. I know that we are having a great and insightful Data Privacy Day. And as Wendy introduced, I'm going to speak about enforcement and remedies and as well as data accountability. So allow me to share my screen for a few slides that I have. I hope we can see it.
I confirm we can see it.
All right. Oops. Okay. So in East Africa, we've passed the era of asking whether to regulate personal data. And the real question today is whether our laws are being enforced in a manner that meaningfully protects rights, deters misconduct, and builds trust. So in this presentation, particularly, we are going to challenge ourselves, particularly as lawyers, to rethink our role, not just as advisors on compliance, but as architects of enforcement, readiness, litigation strategy, and institutional trust. So the expansion of mobile money telecom services, e-government platforms, and digital identity systems, we all know it has resulted in an unprecedented collection of personal data. And from a legal perspective, we know that weak enforcement converts statutory rights into paper rights. Like if we don't have proper enforcement, it's like we don't have any rights in the laws. They will not be enforceable. So if the breaches continue without being investigated and remedies, they remain theoretical. Like we have the laws, we have the remedies on the laws, but if they remain theoretical, privacy protection fails, and at the point where they matter most in practice. So in practice, we need to raise serious questions of, for lawyers, for instance, if we don't act on these breaches, it can be negligence, it can be regulatory exposure, it can be constitutional liability and reputational damages. So we need data protection, and particularly we need to have trust, privacy, and accountability, mainly because we need this law now to become practical and to come into action. Okay. So briefly, this is how we have different laws in different countries across East Africa established at different times. Of course, we know that we don't have a harmonized East Africa, harmonization across East Africa. And coming to the roles of data protection authorities, we have Personal Data Protection Commission in Tanzania, we have ODPC in Kenya, and in other countries, each have their own data protection authorities, but these are the guardians of privacy and personal data rights. They are regulators of public and private sector data use, and they are no longer just advisory bodies. In East Africa, across the countries, they are becoming central actors in regulating digital transformation, especially in telecommunications and fintech, government databases, and credibility of these data protection authorities rather, directly affects public confidence in digital systems. So while the legal frameworks are new, for instance, in Tanzania, the law was just enacted in 2022. And just recently, I think this week, or if not the other week, the Commission extended further the registration of data controllers and data processors to the Commission with a deadline of 8th of April. And so you can literally see that enforcement has not yet started because you're still in the awareness raising. But credibility of the institutions such as this affects public confidence in the digital systems. So as I say, these legal frameworks are new, especially in Tanzania and in other countries, but they have now designated enforcement bodies. So while we're institutionalizing Tanzania in particular, we are going very fast in making sure that enforcement comes into play fast. And the Commission has already received a number of complaints from different people due to data protection breaches. It acts as a push to push the Commission to act on enforcement faster and at a more what we call advanced pace. Okay, so data protection authorities, I'll speak generally across East Africa. Going through all the authorities, there are 4 key tools that are used to enforce compliance, and each is shaping a legal risk. For example, investigations, they detect breaches through complaints and notifications or proactive scrutiny. And there is signaling that violations won't go unnoticed. So this is a signal that no violation will not go unnoticed. And then when you go to audits, they go deeper. They test whether compliance works in practice, not just on paper, and often trigger enforcement action. So there are a number of times where we do the audits that are conducted, and this is it. And then on fines and sanctions, these are applied proportionally, taking into account the severity of the breach, the harm caused, and whether the organization cooperated or acted promptly to remediate. What we can say, these fines and sanctions, they can go with enforcement discretion, because even in Tanzania, for instance, the PDPC will act differently on a company that is more ready to cooperate, that is more ready to acknowledge and admit that there is an error and work through accordingly. And of course, on enforcement and discretion, of which these are the tools, they give the DPAs flexibility. They decide whether to educate, warn, audit, or impose sanctions. For legal teams, this is a risk that is not only about the breach itself, but also about governance, responsiveness, and credibility with regulators. So in short, understanding how the DPAs use these tools is essential for anticipating enforcement outcomes and managing legal exposure. For instance, there are fines up to 10 million. In Tanzania, there are even imprisonments for some of the offenses. So if you know it, or if we know them as data protection lawyers, it helps us to make sure that enforcement, when it comes to play, everybody understands what it is. So diving into audits, they're often the first step regulators take before sanctions. So they assess whether data protection policies are actually implemented. My colleagues have spoken about having data policies, about having policies in place, and then there's a sample of a company that they're shelf, and then the others is just comply for the sake of complying, and then they don't act on the policies. So once there is a challenge or there is an issue, when enforcement is about to take place, audit will start, and the assessment on whether data protection policies are actually implemented will be done. And for legal teams, audits highlight vulnerabilities and offer an opportunity to remediate before regulators escalate. So this is why we need to conduct internal audits so as to make sure that we are on check. And then there is fines and proportionality. In this case, fines are not simply punitive, they are proportionate to the breach. So cooperation, remedial actions, and governance systems can significantly reduce exposure. I think in Kenya, the fines are combined with the public notices. In Tanzania, we're building a proportional framework that balances deterrence and fairness. So we're still bidding it up. The enforcement is not uniform, and public notices, for instance, they do not apply in Tanzania unless the judgment is out, and then people get to know about a decision on a certain matter that has happened. Okay, on enforcement discretion, we have legal exposure is not just about a breach, but also about how organizations respond. Regulators use their discretion to escalate or de-escalate enforcement based on behavior, systemic risk, and cooperation. I think we've seen this most in my jurisdiction, like how you cooperate with the regulator, how you behave. The systemic risk and cooperation that you give will determine on whether the enforcement will be done, or it will be escalated, or it will be taken down. And yeah. So let us see on civil remedies and strategic litigation. So for example, in Tanzania, all the cases on data breaches or on data protection, they go straight to the commission, that is PDPC, and the decision that comes out of there is enforceable, is enforceable, like it can be enforced, and you can go and register it at the High Court for enforceability. But also, if a person is not satisfied with the decision of the commission, they can appeal to the High Court of Tanzania. So in our case, it's mainly the litigation mainly starts at an appeal stage. You cannot start by initiating a data protection case to the court of law. So it's basically the commission is a quasi-judicial body. It has full power to entertain these matters. And remedies and strategic litigations are becoming an important second layer of data protection enforcement. So while data protection authorities, they provide regulatory remedies such as corrective orders, audits, fines, restrictions on processing. On the other hand, courts are to increasingly be used as civil remedies for affected individuals. So for a case of Tanzania, for instance, a person would have to institute a case that is not based on data protection to get the remedies or to get the compensation. Otherwise, the commission will issue the compensation to the affected individuals. And of course, the framework is newer here, but the Act provides for complaints, investigations, and enforcement by the commission, alongside access to the High Court for registration of the award, or in case of appeal, as I've spoken previously. Okay, so we have to look at accountability mechanisms like deterring misconduct and restoring public trust. Accountability works by showing that basically violations have consequences. And when regulators act and courts provide civil remedies, citizens see that personal data is being respected. So the combination builds trust in digital services, which is essential for economic growth and adoption of new technologies. My colleagues as previous speakers, they've spoken about this, they've touched on artificial intelligence technology and how there are issues of consent and other things. Now on enforcement, if really data is breached, consent has not been given, and the person publishes the personal data of a person, and enforcement is done, this builds trust to citizens, and they see that personal data is really respected. We were speaking in the case of Tanzania, for instance. Personal data at some point was not known to be personal. Like even data subjects might release personal data, not understanding that the data is personal, and he's supposed or she's supposed to release it. So the first step, for instance, in Tanzania was is still to raise awareness that this is personal data. You have to have access, you have to have consent, because if people don't understand this, then the body will just be there and nobody will complain. So with time, the knowledge is being passed on, and then people understand that, oh, so this is my personal data. So a person is supposed to ask, or rather I need to give a consent before I release my personal data. And then as a result, once that is breached, now you'd see the complaints increasing in the commission. And there is a certain incident where a breastfeeding lifestylist in the Instagram was just posted a picture of a nursing mother who used their products, and of course the production increased and whatnot. And this lady who is a lifestyle content creator was hesitant, like, no, this is my right. She used my products. So people tried to educate her, like, even though they used your products, you're supposed to get consent to publish that information. And she was adamant. But of course, eventually, the commission, after getting a complaint, dealt with her and she was fined. And I think now this is what we talk about, bringing trust to the people. Like, okay, so if I complain, the commission takes action, and my data now is safe. Now, this is all about the trust that we're speaking about that needs to be built by these authorities. So what we can say is accountability works by showing that violations have consequences. And when regulators act and courts provide civil remedies, citizens see that personal data is respected. So the combination builds trust in the digital era. East Africa is clearly moving towards meaningful data protection enforcement. While still developing, the trajectory is towards stronger accountability, regional convergence, and increased trust in digital governance. So what I can conclude by saying that data protection in East Africa is no longer just about having policies. It's about having real accountability. Enforcement tools, like we've seen them above, the civil remedies, strategic litigation work together. They work together to deter misconduct and to rebuild public trust. Organizations that act proactively, document their compliance, and engage regulators effectively are best positioned to manage legal risk and maintain credibility. So we need to advise organizations to act proactively, have privacy by design, document compliance, engage regulators effectively, so as to best position themselves to manage legal risk and maintain credibility. So I think I'll end my presentation here and allow the next colleague to proceed.
Thank you very much, Dorothy, for sharing these insights. And truly, it's no longer about the paper policies. If we have moved to litigation, enforcement actions, deadlines for compliance, for instance, in relation to registration of data controllers and processors. And as mentioned, even from Tanzania, it's not just fines, we also see imprisonment. And just to highlight, even from Kenya, we've seen the supervisory authority carry out a sector-by-sector audit, and recently announced the audit for the hospitality sector. In the past, I know there was audits for the financial institutions and ad hoc on-volition audits, rather, not because a complaint was raised. Another good point that you have raised is in relation to cooperation of the business with the Data Protection Authority. We have seen quite a number of penalty notices as separate decisions for violations of the specific provisions of the data protection legislation. Also, we've seen, you've highlighted the doctrine of extortion, where complainants cannot initiate data protection complaints specifically with the court first, because the supervisory authorities have been mandated to be quasi-judicial bodies. But of course, there are exemptions where maybe constitutional issues, other constitutional issues have been raised. For instance, the right to freedom of expression, and now it's a constitutional issue that is being framed. So thank you very much, and thank you for the participants also for for raising the questions and the insights in the chat. Keep them coming along. We see them, and I would take the chance to welcome Mr. Patrick Okello, who is a motivated advocate with experience, a multi-jurisdictional experience, so it's quite timely also for the discussion. And he has had the opportunity to work in both Rwanda and Kenya. He is a consultant at Adili Corporate Services, and he is going to highlight what this compliance in practice looks like. I've seen a question on the chat on what this looks like, and from paper policies to operational integrity and etc. You're welcome, Patrick. Thank you very much.
Thank you, Wendy. Can you hear me?
Yes, now we can hear you.
Thank you. The Lord has blessed us with the rain, so it's raining here.
Sorry, it's a bit of a, can you try and speak?
Can you hear me now?
Yes, we can hear you.
All right, thank you. Now I'll say it's raining heavily here, so my network might be a bit shaky.
Okay.
Good afternoon, colleagues. Good afternoon, fellow presenters. Thank you for a very insightful presentation. I will be taking you through compliance in practice, from paper policies to operational integrity. I'm just trying to share my presentation. Is it visible?
Yes, yes.
Can you see? So, as I've indicated, I'll be taking us through compliance in practice, from paper policies to operational integrity. I'll be focusing on 4 areas: that is structuring effective compliance programs in resource-constrained environments, lawful processing models, managing third-party processes and cross-border data transfers, and internal governance beyond tick box compliance. Now, on structuring effective compliance programs in resource-constrained environments, many companies and organizations in the region are, of course, expected to comply with various data protection laws. And this, of course, might, be a challenge to them, especially when they have limited budgets and staffing. So we are in this first part, we are going to navigate through instances where companies have limited resources and still have to meet the compliance measures as indicated by the various data protection laws. Now, it is necessary and essential for companies such as this to adopt a risk-based and phased approach to ensure effective compliance. This, in essence, would mean that these companies should begin with basic data mapping, using simple spreadsheets. These spreadsheets will be used to track what data is collected, why it's collected, where it's stored, and who accesses it. Secondly, the companies and organizations that find themselves with limited resources are, advised to approach implementation from 2 aspects. That is risk-based, to adopt a risk-based and phased approach. Now, this will entail 3 different phases. Phase 1, of course, will entail data protection registrations. So they have to either register with the competent authorities as controllers and processors. Speaking of Rwanda, the process has been made very smooth. For registration, I think you are only required to submit an application letter, application form, accompanied by the company registration certificate and the company profile. Now, there's an additional requirement when the company, of course, is not registered to operate in Rwanda. I think we all know that the Rwandan law has an extraterritorial scope, or companies that are operating in and outside Rwanda, but deal with data of Rwandans are required to register and comply with this law, with the data protection law. So under phase one, there's the data protection registrations. There's implementing a data inventory. A data inventory basically is a comprehensive catalog that lists all the data assets owned, collected, or processed by the company or organization. Then implementing a privacy notice. This, of course, explains how the organization or company collects, uses, and manages personal data. There's also the basic security. Now, under data security, of course, will entail technical and organizational measures that the company or organization has to implement to protect its data from any unauthorized access, alteration, or destruction. This, of course, could include firewalls, encryption, and access controls. Now, under phase two, there is consent mechanisms. Now, consent is a very integral part of data protection law, especially when it comes to processing. Companies should implement ways of collecting consent. I know in Rwanda, consent is collected through 3 different forms: oral, written, or electronic format. So it will be important for companies to put this in place. Then on training, there's training, staff trainings. Staff trainings could be done by the DPO, the one that the company has identified and trained on his or her roles. Then, of course, there's a drafting and implementation of transfer and processor contracts. Under phase 3, we have DPIAs, the data processor processing, data protection impact assessment. Now, this, of course, will entail, instances where the company deals in data that might impact the rights of a data subject. So it would be important for company to adopt this, to adopt audits, and to also undertake breach simulations. This could be, involving the staff members, identifying breach and figuring out how to, solve them. That, of course, will also entail what is the exact procedure when breach is identified, when should it be reported, that is the duration. And the third thing that a company can do, a company that has constrained resources, is to leverage on the existing structures. That is, of course, identifying areas that will require the staff members to, be aware of areas in the data protection law, and handling this through staff data trainings. The DPO can do this. The company DPO can do this. Then you will find that this, of course, will be low cost since it's done internally. Then there's the bit of outsourcing DPO services. Most companies in the organizations, in my knowledge, are now retaining law firms and management consultancies such as ours to assist them with, to execute these DPO services. And of course, that will help them reduce costs. It will also help the company to focus on the more important areas that, it seeks to operate in their operational model. The second bit is on lawful processing models. Now, we know that lawful processing is the foundation of compliance. Each processing activity must, of course, have a basic must have a valid legal basis. The key lawful processing models, of course, are consent, contractual necessity, legal obligation, legitimate interest, and public interest. So in this instance, the data subject has to give his consent in the instance of processing for purposes explained to him or her. Then the processing has to also be necessary for performance of a contract to which the data subject is a party. The data controller also has to execute a legal obligation where he or she is a subject. Then, of course, there's the instance of vital interest. Lawful processing comes in, vital interest comes in as a lawful processing model. Sorry, can you hear me? I've read a comment that I'm not audible.
We can hear you, but we understand that it's raining, so you can proceed. I think we can follow. We are able to follow.
Okay, thank you. And of course, there's a legitimate interest and public interest. I think these bits form lawful processing models that are very key in the processing of data. Now, companies and organizations have to maintain a lawful basis register and ensure that this, the privacy notices reflect the purpose of processing, the legal basis, the retention period. And now in Rwanda, there are other laws that indicate, for example, the company's law, 10 years for retaining data, but the law itself indicates that data can be used until can be retained until its purpose is fulfilled. Then the recipients. So legitimate interest. In this instance, we've mentioned legitimate interest, the key lawful processing models. I just wanted to mention it because it's one of the 6 key lawful processing models, and it is very key, especially considering the fact that it allows the data processing if it's for a legitimate reason and necessary, and if it is necessary, provided it does not harm the individual's rights. So companies should also note that this processing of data has to be for a legitimate purpose. I'll finish this bit again with consent. Consent, as I've indicated before, is a very integral part of data protection law. It is, in essence, it should be freely given, specific, and informed and unambiguous. It is, of course, related to all these key lawful processing models. So when a company is implementing, these processing models, it should also indicate that consent can be withdrawn at any time. Then, of course, there's the bit of, reviewing the processing. Companies should regularly review their processing as the business activities evolve. On the next part, managing third-party processors and cross-border transfers. Now, I think it cuts across all our laws in the region that data controllers are responsible. That data controllers are responsible for outsourced processing. Under Rwanda's data protection law, processing of personal data by the data processor has to be governed by a written contract between the processor and the controller. Now, this written contract has to, of course, lay out responsibilities that the involved parties are going to meet. It also has to indicate the technical and organizational measures that have been put in place in regards to how the personal data is stored, transferred, altered, processed, accessed, and used. It also defines the limits, within which the controller, the processor, and third parties are going to process personal data. Now, going to third parties, third-party processors, they play a very important role in the operations of companies and organizations. It is important to note that when a company or an organization is using a third-party processor, it sort of puts itself in a place where it could pose certain risks to data security and compliance. Therefore, use of third-party processors should be done with keen, there should be some keen matters that are noted when engaging a third-party processor. And of course, the use of third-party processors will require the company to implement two important documents. That is a data processing agreement and the data protection impact assessment. We've discussed the DPIA before, but I wanted to indicate that all processors must be governed by the DPA, the data processing agreement. And this data processing agreement, it should be very clear. The clauses must be very clear. I'll draw an example from Rwanda. The Rwandan Data Protection Office published a guide on contractual provisions that are mandatory. They have to be included in the data processing agreement. So the guideline is it's available online. For those interested, you can check it out. So in a nutshell, two documents have to be considered when engaging third-party processors. One, the DPA, Data Processing Agreement, and two, the Data Protection Impact Assessment. We had indicated that the Data Protection Impact Assessment is essential when processing activities that are likely to result in high risk to rights and freedoms of individuals or data subjects. So it is important to also note that this DPIA, the Data Protection Impact Assessment, has to be implemented by both parties, the processor, that is a third-party processor, and the data controller. The processor should have the DPIA that relates to their processes and mechanisms that they are put in place to reduce their likelihood of impacting a data subject. The controller should also conduct a DPIA that shows that they've completed due diligence on the third-party processor and that controls are in place to mitigate any risks with this processor that they have engaged. So in a nutshell, also to complete that bit, I indicate that companies and organizations should maintain a processor register and conduct due diligence covering security measures, data collection, past incidents, and also to ensure that the third-party processor that they are subcontracting is indeed has indeed complied with the requirements of the various relevant laws. Now on cross-border transfers, I'd indicate that first I'd draw an example of Rwanda. In Rwanda, the transfer of data outside Rwanda has to be done, upon meeting various conditions. One of them, of course, is obtaining authorization from the supervisory authority, the National Cybersecurity Authority, upon providing proof of safeguards. Then there's the issue of obtaining and where the transfer is necessary. Now the law has provided instances where transfers will be necessary. Now, cross-border transfers must rely on appropriate safeguards. This will include, adequacy decisions inadequacy decisions, of course, are formal. An inadequacy decision basically is, involves a formal determination by the competent authority, in Rwanda's instance, the NCSA, that a foreign country has implemented, as a high level of data protection that is comparable to Rwanda's standards. If this is deemed adequate, then organizations may be allowed to, transfer personal data to that country without seeking special authorization for each transfer. Then the second bit is contractual clauses. Under contractual clauses, these are legally binding agreements, that should be put in place, requiring the recipient, the one receiving the data, to protect it in line with the Rwanda's laws in the instance of Rwanda. So again, Rwanda has published standard contractual clauses. They are available online for personal data transfer. Then the last bit here is binding corporate rules. Now, internal data protection policies that are adopted by companies and organizations, these are better to regulate how personal data is transferred within the group. In the instance, a company operates, such as regional companies, banks, and all that are noted are operating within the region. It is important for them to have binding corporate rules that regulate how personal data will be transferred within the group across different countries. Now, these transfers should also document the types of data, destinations, safeguards, and purposes. Why they are, why transfer the data outside the country. The last bit is internal governance beyond tick box compliance. Now, our discussion has been about, basically compliance in this age of, data protection. Now, under this bit, I note that, we might have, all these, policies in place, but ultimately what will matter is, the organizational structure and culture. It will be important for companies and organizations to move past this formal approaches, like drafting policies, documents, and instead, embed these data protection practices into the company's culture and daily operations. So I will state that the company leadership must demonstrate commitment, and by this I mean they should ensure that compliance responsibilities are decentralized. That would mean identify who is in charge of what, especially where a company is required to have a DPO. It would be important to have one who is well qualified and knows their roles properly. And then the companies should also ensure that the breaches, they are well prepared for any breach and what response plan in place. In essence, they should in some instances even organize indicated these breach simulations. In the event there is a breach, what steps should be taken and who should do it? Who is responsible? That will go along in ensuring the governance is well structured. Then I'll finish by saying that privacy should also be embedded into the different areas, in the different departments of the company. Procurement, IT, HR, they should all be very well very well versed with the requirements of the law, with the practice on how to handle data. that comes in and out of the company. That is basically my presentation. Thank you.
Wow, thank you very much, Patrick, for your insight and also for reminding us about some aspects of the specific legal frameworks. For instance, you have reminded us of the legal basis, also bearing in mind that none of them is superior to the other, and that consent is not the only legal basis. Thank you also for reminding us of the mechanisms of data transfers, including adequacy decisions by the respective data protection authorities, BCRs, or otherwise binding corporate rules as stipulated in some pieces of legislation, for instance, the Kenyan Data Protection Act, and also standard contractual clauses, among other mechanisms for data transfers. And this discussion has reminded me of a decision that was issued by the Ugandan Data Protection Authority against a big tech company, and one of the violations related to the failure to register as a data controller and processor, and also it related to the cross-border data transfers in relation to that this big tech company was carrying out. And also just to touch on in relation to data transfers, this morning we have news from the Kenyan Data Protection Authority. Some interesting news. The DPA, or rather the ODPC, launched a report titled Data Without Borders, which is quite a timely report because it highlights the economic impact also of data flows and an evidence-based analysis to support the implementation of the Act. Also, as confirmed this morning and also in the past by the Kenyan Data Protection Commissioner, Kenya is currently in the process of negotiating for an adequacy decision with the European Union. So we will, of course, see how that will come in play. So moving on, I think there's been quite a bit of interactions from the members as well as the guest participants in general in the chat. And I would, in the interest of time, I would briefly invite my fellow panelists in less than 2 minutes to just summarize and gather up the questions and quickly answer that. I think for me, there was just one question from Daniel, which they asked whether you can get a link to the book. The book titled by Dr. Joy is called Unmasking AI, and the film is called Coded Bias. So you can quickly check that online, and that will be available to you. So I would like to take the chance to re-invite Alfred, who would take the questions in relation to AI, which have been quite a bit of a discussion in the chat. Alfred, in 2 minutes, and then we can proceed to the other panelists who would very quickly summarize the answers to the questions posed by the participants in the interest of time, and then we can close the discussion for the day. Thank you very much, and I would invite Alfred.
Thank you so much, Wendy. I believe I'm audible, and
Yes.
I think there are quite a number of questions on AI, but I think most of them are related. And the first one is Angela asks if consent is really enough in the age of AI, and the answer is no. Consent is not enough. Even if informed consent is the foundational principle of data protection, however, is not enough in this age of AI because of issues of AI black box, opacity, lack of transparency, and therefore data controllers need to do more in terms of ensuring that there is transparency and accountability, privacy by design, a lawful basis of data processing, among others. There is another question which asks, let me get the question, sorry. Whether the current laws are too focused on individual rights rather than systemic AI harms. How should the law respond to AI privacy harms that affect groups rather than individuals? This is a matter of data governance, and there is a number of models which have been proposed in terms of data governance for collective rights for groups. And there are issues of information fiduciaries, data trusts, data stewardships, and basically these are where people pull together their personal data so that they can be managed by a central, let me say, a platform. And basically it's more or less of where people are able to enforce their collective rights. So I think apart from the individual rights, people enforcing their individual rights, there's been proposals to have collective rights for groups, especially in the EU. I've seen data stewardships in the EU. I've not seen one in the continent or in East Africa, but I'm sure we'll get there. There is another question which asks that in Kenya, we have CCTV cameras everywhere and no signs to give people notice that the CCTV are in use from Veronica. And the answer is basically, I've seen a lot of data protection authorities in East Africa, Kenya, Uganda, Tanzania, have published guidance notes on the use of CCTVs and private security. And basically, one is there should be a sign that there is a CCTV in use, and there should be a lawful basis as to why you are using that CCTV in your premises and for what reasons. Then there is another question on surveillance too, which says that surveillance should be objective. I don't understand how the test on AI surveillance should be objective and not subjective. Okay, let me respond to that with a case which was determined by the High Court of Kenya. And the case, the citation is Okia Omtata versus Community Authority of Kenya. I think it's a 2018 or 2019 decision where the High Court was of the view that surveillance should be objective and not subjective, and that surveillance should be in accordance with the law, and it should be proportional and necessary. So you can have a look at that case, Juliet. I think there's another case, there's another question, or more or less like a comment, and Angela is saying that we now have AI systems. Oh, it's talking about liability of AI. So basically, in terms of liability of AI, first of all, we don't have an AI legislation in East Africa, but what we've seen is the countries coming up with national strategies on AI, but they're still silent on some of the things, especially the risks and harms which AI poses. So basically, in terms of liability for AI, then we approach the matter from the existing liability contexts in tort, things to do with negligence, breach of contract, strict liability, and that is the approach I've seen even the European Union use in terms of apportioning liability on AI systems. So that one, we go through the tort liability system and things to do with negligence and all that. I don't know if we have another AI question. There's a person saying that AI should be regulated from a sectoral approach, which I think to me it's a good approach. But again, the European Union is currently using a risk-based approach. They classify AI systems into unacceptable risks, which are prohibited. We have high risks, limited risks, and AI system which pose no risks. There's been a proposal again to regulate AI from a right-based approach. And I think in terms of sectoral approach to AI regulation is a good approach. And I think the US is using sectoral approach to data protection. That is, there are various data protection laws in various sectors, such as the health. I think they have a HIPAA for health or something. So I think it's a good approach, but again, we have to look at which is the best approach to regulate AI, because because of the risks and harms which AI poses to fundamental rights. Wendy, I think those are the questions I can see from my end on AI, unless I've missed one.
Thank you very much, Alfred, for taking those questions. I would invite David, and maybe you can take questions related to your expertise. Thank you very much. And please, in the interest of time, I would not, it's not my intention to cut you off, but just stick to 2 minutes. Thank you very much.
Okay, thank you very much, Wendy. I think for me, I've looked through the chat and I believe it's like only 3 questions that speak to my presentation specifically. I think the first one is Dennis, who asked what is a sovereign cloud. In my presentation, I talked about the difference in cross-border data handling between Kenya, Uganda, and Rwanda, and I gave the example of Rwanda requiring data to be stored first in Rwanda. And then in order to store it outside, you need an extra authorization from the National Cybersecurity Authority. So what is a sovereign cloud then? So a sovereign cloud is simply a service that is designed to store and process data within a specific legal and geographical boundary. So it's sort of like the solution to what Rwanda is requiring. So if they're saying that data must be stored in Rwanda, then a sovereign cloud is one that is dedicated to ensuring that data remains stored within the geographical boundaries of Rwanda. That's the first question. Second question is from Feni, who asked, how can a data subject enforce their data rights in case of cross-border data breaches? And the thing about protection of your personal data, that protection must always begin with the data subject. The data subject must always understand their rights. For instance, who beyond your borders is collecting the data? This is the first question that you're asking. Have you authorized them to collect that data? Have you consented? If you have, then there's also other opportunities that they must provide as a matter of law. For instance, in their data policy, they must clearly explain that this is where you must report a data breach. This is who you can complain to. For instance, if they have a data protection officer, there'll be most companies currently are certain to put that information out there. So you should always go to the bottom of a website, look for the data protection policy, and then scroll through to look for breach. All those instructions must be there as a matter of law, regardless of the jurisdiction. That question relates to the third question that was raised by Faith. Do social media platforms like Instagram have an obligation to create dedicated data breach portals for reporting? The answer to that is simply yes. In relation to the same answer I gave Penny, all these platforms must provide data breach response platforms, whether it is through the data protection officer, through some sort of compliance officer, whether it is MTN, whether it is Instagram, whether it is WhatsApp. In their data protection policies, the procedure for complaining regarding data breaches must be elaborate. Thank you very much.
Thank you very much for this. David, I would invite Dorothy to answer the questions addressed, rather possibly addressed. Thank you very much.
Okay, thank you, Wendy. I think I got one question, and that was, I'm trying to get it. When conducting the audits, especially routine or sector-specific one, what kind of operational evidence do DPAs rely on to assess whether governance and safeguards are actually functioning in practice, rather than existing only as policies or one-time controls? So in answering this, in audits, the DPAs look for operational proof that data protection works in practice, not just policies on paper. So they rely on evidence that governance is active, embedded, and continually applied. For instance, you can have something like living governance records, something like committee minutes or DPO involvement, escalation logs, and budgeted privacy functions. That is one thing. Another thing, you can have active technical controls, something like access logs, encryption reports, change management, and security testing records. And then there is something like real risk management, like the DPIAs. How are they tied to actual projects with implemented and reviewed mitigations? Because you can conduct a DPIA, but it's not tied to the actual projects of a company. So that is just like checking the box or ticking the box and not actually making it practical. Also, you can have things like things that are being checked, such as third-party oversights, like ongoing vendor monitoring, data sharing records, exercised audit rights. So continuous monitoring like KPIs, internal audits, things like those, trainings, effectiveness. For instance, you can have trainings, but if they're not effective, if the assessment and the evidence that the staff can apply rules and real scenarios is not there, definitely you will be known that you have not practiced make it into action, the policies. Also something like policy in action proof, the SOPs of the company, the system screenshots, the approval workflows, audit trails. Actually, if you are actually working on making these policies into action, there will be trace, there will be evidence. It will show it will definitely show. So yeah, that is it on answering that question. I'm not sure if I got another question. I've only caught this one. Thank you.
Thank you, Dorothy, once again. And lastly, I would like to invite Patrick, who would wrap up the Q&A session with the insights he shared. Thank you.
Thank you, Wendy. I've noted one question asking how often Rwanda does DPIAs. Well, under the requirements, especially when a company or an organization is applying for transfer or storage of data outside Rwanda, one of the supporting documents or requirements is a DPIA. So you're required to, when you are transferring, to draft a data protection impact assessment for transferring personal data outside Rwanda. Same applies to when you are, seeking to store data outside Rwanda. And maybe the beauty of this is the Data Protection Authority has come up with a guideline just to, make your work easier on what are essentially required to be included in your DPIA. I don't know if there's another question. That is the only one I saw in.
Okay, thank you very much again, Patrick, for your thoughts. Once again, hope I see you asked the title of the book again. Sorry, I wasn't clear. It's called Unmasking AI by Dr. Joy, and the film is called Coded Bias. So once again, I would like to wish you a happy data protection day, and as we think about how we are going to translate this thoughts and insights into either our business practices or our clients' business practices. I would like to give the floor to our very able convener of the day, Gabriel. Thank you very much. And once again, I wish you all a lovely afternoon. Gabriel.
Thank you, Wendy. Thank you so much, Alfred, Patrick, David, and Dorothy, for that very wonderful session. As you can tell, the numbers have been constant from the beginning. And to our audience on YouTube, we are sorry some of the questions you were raising were not attended to, but we will transmit them to the panelists and in due course reach out to you with the responses. But it's been an amazing session. It's been captivating and thought-provoking, and thank you all for making this possible. So as we conclude, friends, tomorrow we'll have yet another session on corporate governance in a modern era, and this time we'll be looking at AI accountability ESG enforcement, and boardroom risk management. So if you're a corporate law enthusiast there, and if this is your area of practice, you certainly do want to join that conversation. And of course, next week, like you all know, we'll be having our physical training session on legal and parliamentary affairs. It's a masterclass that has been convened for 5 days right here in Arusha, Tanzania. So if you are an office administrator and you work in a legal office, or if you have a law firm and you want to empower your legal office administrator, please, this training is the right one for them. So you can reach out to us at info@elawsociety.org, and we'll be more than happy to attend you. Otherwise, from us to you, we are extremely grateful, and we will share these presentations and a recording, link to the recording so that you can listen in and keep analyzing some of the aspects that have been discussed here. Until we meet again tomorrow, have yourselves a very lovely afternoon. You stay blessed, and God bless you all. Thank you.